Good evening. Hope everyone is well and remains healthy during these very uncertain times, and that you had a chance to enjoy the gorgeous weather this weekend. As I mentioned, we are recording the program. If you would be so kind to mute yourself to reduce any background noise. So on behalf of the League of Women Voters of Massachusetts, welcome to tonight's briefing on qualified immunity and police reform legislation with Oami Amarasingham, Deputy Legislative Director of ACLU, Massachusetts. My name's Jen Muroff, and the Racial Justice Subcommittee members Kathleen Leonardson, Pat Costello, Susan Lafredo, Sue McCauley, Bedna Lacombe-Haywood, Tracy Brown, and Paul McLaughlin, and we're all excited to host you this evening. We're pleased to have LWVMA Co-President Judy Zombrocker here as well. This is the third briefing in our racial justice series. We hosted Rep. Miranda on July 13th, Rep. El Ugardo on August 31st, and this coming Thursday, September 10th at 11 a.m., we'll be hosting Rep. Carlos Gonzalez, the chair of the Massachusetts Black and Latino Legislative Caucus. So just to recap for folks who haven't attended before, just to ground us in tonight's discussion, League of Women Voters is committed to racial justice at the local, state, and national levels. To quote our LWVUS president, Dr. Deborah Ann Turner, we must address the ongoing and inexcusable violence against Black people in our country. We strongly oppose the systemic racism that allows violence like this to occur repeatedly. The League remains an ally to those leading the work for social justice, and we encourage all leagues to advocate for Black lives and nonviolent protest. At the national level, the LWVUS passed an urgent resolution at National Convention.
Yeah, we are.
Everyone can go ahead and mute. I want to make sure everyone is muted. Great. For Black people and all people of color, drafted by current director Bedna Lacombe-Haywood. The resolution states, first, the League advocates against systemic racism in the justice system and, at a minimum, for preventing excessive force and brutality by law enforcement. We also call for prompt actions by all League members to advocate within every level of government to eradicate systemic racism and the harm that it causes. Based on our briefing with Rep. El Ugardo, we know that the conference committee is working to finalize police reform legislation and that the two main sticking points are qualified immunity and the composition of the Certification Review Board. The four main police unions and the Black and Latino Caucus had agreed through many months of negotiations to the state level provisions in the caucus's 10-point plan, but qualified immunity had not been included when they were negotiating. When the Senate bill was unveiled and it included qualified immunity, police union members launched a massive misinformation campaign on numerous levels to their legislators and to the public, claiming that anyone who supports police accountability is opposed to the police themselves. So that's why we've brought in an expert to understand what qualified immunity is. So Oami Amarasingham joined the ACLU of Massachusetts as Deputy Legislative Director in September 2019 after 7 years at the Maine affiliate. As Advocacy Director there, Oami advanced the organization's legislative agenda, working to pass first-in-the-nation privacy laws, expand access to reproductive health care, and reform Maine's approach to drug policy. So welcome, Oami. So we thought we'd kick it off. We can just start with a few questions just to discuss the basics of qualified immunity, and then what we can do is open it up to questions within the chat. So why don't we get the conversation going? Let's see. So Oami, can you just explain the basics of qualified immunity to start?
Yeah, absolutely. And thank you, Jen, and thanks all of you for having me at your meeting tonight. I'm a big fan of the League of Women Voters. I realize now that we're all on Zoom that when people read my bio and they say the Maine affiliate, that might sound like the most major affiliate. but it's the ACLU of Maine as in the state of Maine. So I should change that because in writing it's obvious, but it's happened a couple of times that I think when my bio is read out loud, I'm confused by it myself. So thanks all for having me, and thanks for all of the great work that I hear from Jen that you all are doing in your communities. We're always so grateful to be partnered with the League and all of your members. So I'll just jump in with a little background about qualified immunities, qualified immunity 101, if you will. And I'm really hoping that this will be a back and forth conversation, and I'd love to respond directly to whatever questions that you have or that you're hearing when you have your meetings. This is a confusing topic. The principle is I think is quite clear, but the actual details are confusing. And when I was in law school, I remember being very, very confused about it. So I want to also express that I am impressed with how quickly folks on the ground who are meeting with their legislators and their police chiefs are becoming experts on what has taken many legal scholars and lawyers a very long time to grasp. So y'all, I'm sure, are doing a great job. So qualified immunity is basically a defense to liability. So it is immunity from liability specifically for violating constitutional rights. So it comes into play at both the federal level and at the state level. So at the federal level, there is a law that is referred to colloquially among lawyers as Section 1983. And that is the law under which civil rights litigation is brought. And it allows individual plaintiffs and private citizens to sue the government when the government violates a person's constitutional rights. Massachusetts has a state statute that mirrors Section 1983 called the Massachusetts Civil Rights Act, or the MCRA for short. And that was enacted in the 80s. And it is meant to be the way for residents of Massachusetts to bring constitutional claims in state court or federal court against state actors in Massachusetts. And qualified immunity is a defense that applies both to the federal statute 1983 and the MCRA. And it is a doctrine that was invented by judges. It's an important factor that it is not a legislative action, either at the federal or state level. So this is a judicially invented defense. And it was invented by federal courts in the 60s to shield government actors from the burden of litigation. And it has been expanded steadily, really ramping up in the 80s, and in the view of civil rights lawyers has gotten way out of control since, to basically mean that government actors, and we most often see this in cases brought against police and police departments, are basically can act with impunity. The doctrine at its base says that unless the law was clearly established that what the officer did was a violation of civil rights, the officer cannot be held liable for that action. And that sounds reasonable. Maybe that sounds reasonable. I think if you analyze it a little deeper, that creates a double standard, because ignorance of the law is certainly not a defense for regular people like you and I. It doesn't matter whether or not we knew what the speed limit was. If you're over the speed limit, you get a speeding ticket. So it already sets up a double standard that allows state actors to claim ignorance of the law and therefore not be held liable. But even further, it is a problem because those words clearly established have been interpreted extremely strictly and narrowly to basically mean that unless the exact same harm has happened to someone before, or the exact same harm was contemplated and prohibited explicitly in a policy or statute, you are out of luck. And that has created a situation where people who are victims of police brutality and other kinds of egregious constitutional violations can basically not recover in court unless the exact same harm has happened to someone before them and that person has litigated the case. So the first person who brings the case is not going to be able to get relief. So that is a huge problem because it means that victims of police brutality bear the entire burden of the harm. They bear all of the injuries, they bear all of the medical costs and funeral costs and any other costs associated beyond the trauma and generational trauma that exists from violent policing. And in addition, courts have taken this idea even a step further to say that since qualified immunity exists, and we know that this officer can't be held liable even if a constitutional right was violated, there's no real point for us to go through the inquiry to decide whether or not a constitutional right was violated. So what we have in addition to people being harmed bearing all the liability themselves is that the constitutional law is stalled and it does not develop because courts do not examine the facts of cases because they sort of, it's a circular problem that they jump to the end and say, even if there was a violation, there's no liability. So therefore, we're not going to examine whether or not there was a violation because there's no point, because there's going to be no relief. So that's a real bummer. And there has, for a long time in the civil rights community, been a movement to reform the doctrine. There have been litigation strategies across the country to try to narrow qualified immunity, but what we have seen is that courts keep expanding who is entitled to qualified immunity. So at this point, all kinds of law enforcement officers at the local level, at the federal level, Border Patrol officers are all, there was a Secret Service case some years ago. The Secret Service is now entitled to qualified immunity. So basically qualified immunity has been expanded so far that it functionally means that civil rights litigation is stalled. And then the fallout from that continues on, that civil rights attorneys will be reluctant to take cases because they know that cases are not going to get very far. They don't want to waste people's time. We don't want to waste resources. So you get a situation where people don't even bring the cases now that they should be entitled to recover under because recovery is futile. So there is a movement, as I said, amongst constitutional scholars and lawyers and civil rights litigators to abolish qualified immunity altogether. And there are folks on the left and folks on the right, the Cato Institute, the ACLU, the Alliance Defending Freedom, which is a very conservative, anti-LGBT, anti-choice organization that is usually on the other side of litigation from the ACLU, but has joined with the ACLU to fight qualified immunity. Clarence Thomas believes that qualified immunity ought to be reformed. So there are a lot of folks on both sides of the aisle that think qualified immunity should be reformed. And it is unfortunately the case that it doesn't seem like reform is going to be possible through the courts. And so increasingly states and Congress are looking to abolish or reform qualified immunity through legislation. The other thing that I meant to say earlier that I just want to return to quickly about qualified immunity in Massachusetts is that the Massachusetts Civil Rights Act was enacted, as I said, in the 80s. And the statute itself is silent about qualified immunity. And when one of the first cases got to our state Supreme Judicial Court, the SJC, the court decided against the plaintiff and said that qualified immunity applies and the plaintiff couldn't recover because the court said when the state legislature passed the MCRA, qualified immunity had already been adopted in the federal courts. And since the legislature did not say anything about qualified immunity, we assume they were aware of the long line of cases at the federal level and that they meant to include qualified immunity as a defense to the MCRA. As someone who does a lot of legislative work with legislators, that kind of thing is infuriating to read because I doubt that every legislator who voted to pass a bill called the Massachusetts Civil Rights Act was acutely aware of the way in which the Supreme Court was going to expand the defense of qualified immunity to mean that nobody could recover for their civil rights. But nevertheless, the SJC believed that the legislature, in its silence, implicitly adopted qualified immunity as a state defense. And so the MCRA, because of qualified immunity and because of a few words in the statute that have been very narrowly interpreted as well, has basically been a meaningless statute. People have not been able to recover in Massachusetts for violations of civil rights. So reforming qualified immunity is a top priority for the ACLU to make the MCRA a statute that actually provides relief for civil rights violations, which is what it is supposed to do.
Great, thank you, Omi. That was great. And we actually have one question that is one person asking, are there any states that already limit qualified immunity at the state level?
So Colorado most recently eliminated qualified immunity for police and I think other law enforcement officers as well. They did that very recently, a few months ago. They had like us, they had a bill about qualified immunity that was moving, and then that they passed it in June, I think. Interestingly, they did it a little differently. They were sort of at the beginning stages of creating a Colorado Civil Rights Act. And so they did what we now wish we had done in the 80s, which is they adopted a state cause of action to bring civil rights litigation against law enforcement. And they wrote into the statute that qualified immunity is not a defense. And so in some ways, procedurally, I think it was a little simpler for them than we are finding that it is for us, since the state cause of action didn't really exist in the first place. But they're the most recent example. I am not, so as I said, it's courts that have interpreted that qualified immunity applies. I don't know in other states whether every state court has interpreted that qualified immunity applies at state level litigation. It also depends on whether state level litigation for civil rights is an option in other states. But Colorado, as far as I know, is at least the most recent, if not the only state so far to do this legislatively. So we're hoping to be number 2.
Great, thank you. And could you explain the difference between indemnification and qualified immunity? Because I think there's a lot of confusion around that, especially with the police calling their legislators.
Yes, absolutely. So indemnification comes after liability is assigned. So first, and it's also important to keep in mind, because one thing that has happened is, or with the misinformation campaign on the other side, is they have compressed the legal process to what feels like a very quick and rash timeline, which I think everyone here will know that constitutional litigation takes an extremely long time, and it is very hard for average people to win. The House always wins. And that is generally true in constitutional litigation as well, that the government, there's a lot of deference afforded to government actors at every stage of the process. So if a plaintiff makes it all the way through from bringing a claim, all the motions to dismiss, the summary judgment phase, discovery trial, and actually there is a finding that a person was harmed, and that harm was so egregious that the government actor, the police officer, for example, ought to be held liable. Indemnification comes in after that. So it would, after liability is found, the officer's employer, the town or city or state, as it were, would indemnify the officers so that they would not be personally liable. They would not pay out of pocket for whatever the award is. It works the same if you think about any insurance situation where your insurance company may be fighting with the other driver's insurance company because they want to be indemnified by the other insurance company because they don't want to pay the cost. So it's a similar concept. And that is the way that a lot of employment litigation works. If you are on the job and you on the job as part of your job function cause harm to someone else, your employer is likely on the hook for that, which is why many employers carry insurance. Malpractice is sort of an easy example of how that works. my office has malpractice insurance. If any of our lawyers cause harm to any of our clients, our malpractice insurance will cover that to a certain extent, unless the harm is so outside of what could be expected. And that, I think, is true. I actually imagine that many of you may know more about malpractice insurance and how that works, but it would be similar here, that for the most part, the employer would pay unless the award is above a certain amount, or unless the violation was so outside of what sort of like moral rules we have laid down that you are operating outside of what the insurance will cover.
Thank you. And can you give a brief description of how the House and Senate versions differ and why we should support one over the other?
Sure. So the Senate version reforms qualified immunity, and it sort of flips the presumption so that the burden is on the officer to show that his or her actions were clearly legal, instead of what we have now, where it's on the individual plaintiff to show that the law was clearly established in that the violation was a violation, which courts again have interpreted very narrowly, that unless the exact harm was written down somewhere or there was a case on point that has already been litigated, the law is not considered clearly established. So that is a meaningful reform. I mean, I'll say the ACLU supports abolishing qualified immunity, and will continue to work towards that. But this, at the very least, would give plaintiffs a chance to argue their case in court, and we think would also incentivize people who have suffered great harms to bring litigation and allow the constitutional law to develop, even if courts decide those are not constitutional violations, or the defense would still be available to government actors to say that, hey, what I did was clearly legal, and here's the policy, here's my training, here's the case that happened before that held that this was clearly legal. So it would sort of unstick the place that we're at with qualified immunity. On the House side, the reform is much, much, much narrower in a couple ways. First, it could be interpreted to only apply to lawsuits brought by the Attorney General. The language it's not clear, and it's not clear whether that's the House's intent or not, but it amends the section of the MCRA statute that applies to the Attorney General, which could be troubling, but could also be overcome. The part that is most troubling about the House language is that it ties qualified immunity reform to the decertification process. So it says that in a lawsuit brought by the Attorney General against an officer that has been decertified, qualified immunity shall not apply. So it removes qualified immunity as a defense at all. That's great. But it only applies if the officer has already been decertified. And that's a problem for a few reasons. One, it will drag out the timeline, because we don't know how long it will take this commission to get set up. And once it is set up, we don't know how long their process will take. And the process of investigating and decertifying an officer may take a very long time. And in all of that time, if a person is waiting to bring litigation, they are still bearing all the costs of violence and brutality. Evidence is growing cold. People's memories are fading. You lose a lot the longer you wait. And second, and perhaps most troubling, I think it sets up a situation where the commission is going to be very reluctant to decertify officers, because there will be political pressure, as there is now, for them not to act, because it will expose officers to liability, which, as we know, is something that elected officials and people appointed to boards and commissions don't want to do. So linking the two undermines both the decertification process and the qualified immunity reform, and in a way that feels like they sort of cancel each other out, that bad officers will never be decertified unless, it's really hard to imagine how bad the activity would have to be, because we are witnessing right now in these weeks the most terrible behavior by law enforcement officers, and maybe they are just the bad apples, but the behavior is really atrocious, and it's hard to imagine how much worse it would have to be for there to be strong action. So the House reform is narrower and also makes that troubling link between the decertification process and civil rights litigation, which really ought to be two separate tracks. Decertification is about whether or not you are qualified to do the job, whether or not you have done your job well or not well. And civil litigation is about that, but it is also about making the person who was harmed whole again, or at least attempting to. And that is something that still feels like it would not be possible under the House version of the bill.
Okay, so why don't we there were several questions in the chat. So why don't I open up the chat and ask some of those. Mary Sullivan asked, can you talk more about the misinformation campaign? I saw elected officials who literally copied and pasted the talking points being put forth by police unions. Same, I definitely saw those. For example, a common one was using the fear tactic, trying to say that first responders would hesitate to provide CPR for fear of being sued.
Yeah, there has been a lot of unfortunate misinformation, and it is certainly true that law enforcement officers and first responders and others have to make split-second decisions, but that is already accounted for in the first part of the litigation. So the initial question should be, was a constitutional right violated? And first, you have to establish that you had a constitutional right to certain behavior, which is not going to be, if someone is, that is already a high bar to tell a court that there was a constitutional right here of mine that was violated. So that is often very serious, egregious conduct. And the question of whether or not it was violated already takes into account whether the government actor, the first responder in this case, acted reasonably from the perspective of a first responder. So as long as the first responder is acting in good faith, if you will, and in accordance with their own training and with the standards and practices of the profession, you will not get to the liability phase, because there is no liability unless you have acted unreasonably for someone in that situation. So qualified immunity, again, only really should only come into play after we've established that there was a constitutional violation, and a constitutional violation so bad that there is going to be liability, that there is going to be a reward of damages or punitive damages because someone has behaved so far outside of what is allowed or expected of their profession. So qualified immunity reform should not affect the split-second decisions of law enforcement officers. And I'll also say that in many other professions where the stakes are very high, people who do the wrong thing intentionally or recklessly are held liable. So doctors and surgeons also have to make split-second decisions that are life-changing and can go the wrong way and end someone's life. And there is a whole system set up to investigate whether or not that was the appropriate decision, whether a doctor was at fault, whether the doctor should be held liable for that. And that system works to create accountability and regulation around the practice, and it influences training, and it makes doctors have to redo their boards every so often, and that is because they need to stay on top of the latest research and the latest techniques so that people are getting the best possible care and the most up-to-date care. And a similar system has ceased to exist on the law enforcement side. And so I would say, because of the kinds of decisions that first responders have to make, we should be really invested in making sure that they are making those decisions really well, and that there is a lot of training, and that there is ultimately accountability. Accountability liability and litigation are the language of accountability in America. And because there is no legal liability, we see police officers and law enforcement officers acting with impunity.
Thank you. Okay, from Judy Zombrocker. How much does it cost municipalities when there are settlements for victims of police misconduct and brutality? Is this related to qualified immunity?
That's a really good question. And we have a little bit of a catch-22 because of the way qualified immunity works. There are not a lot of these awards that happen. There are, and also because of the way litigation works in the US, a lot of settlements are secret, so we don't know what the awards were when they happened. But there was a study which in 2014, which I can share the link with Jen, and she can pass it around, that showed that police are indemnified for more than 99.9% of the judgments against them. And in the 4 Massachusetts cases that were examined, none of the individual officers were held liable. I think that the indemnification, there are some towns and cities, I think, have ceilings of how much they'll indemnify for. This is a question that has come up a few times, and I know that we're trying to answer it ourselves about how it works town by town. There's not a uniform rule across the state, as far as I know, about how much towns and cities will indemnify. But I believe that some towns and cities have a cap, and after that, I imagine that officers would have to pay their own legal fees. And I know that other people have raised the policy idea that municipalities and officers should carry some kind of insurance to cover these costs, and that is, people on civil rights advocates have different views of that. The ACLU does not have an official position on it, but again, we do believe that money talks, and the threat of having to pay out big settlements will, in other sectors of employment, definitely means that training changes and investments are made, serious investments are made to prevent that liability, and that can lead to better care and better outcomes.
Great, thank you. Okay, just going into the chat for some more questions here. Okay, from Charles Hornig. As a volunteer town official, planning board member, I'm concerned the effect of this on local officials. Members of all of our boards, select board, planning board, school, zoning, historical, have been sued for constitutional violations over the years.
Yeah, again, I would say, well, and we've had several conversations with other public sector unions who had similar concerns about how this was going to affect them, and it has been a specific tactic of the police unions to say that this is a problem for everyone. And in response, we had a lot of conversations with public sector unions, and very many of them came on board in support of these reforms. A few in support of just reforming qualified immunity for police, and a few in support of across the board reform. And one point that came up over and over is that there is a reason that most public sector officials and public sector employees have never heard of qualified immunity. And that is because it doesn't come up in most professions. Again, because the first inquiry is whether or not a constitutional right has been violated. And you only actually get to that inquiry after a court determines that a claim is not frivolous, and there are merits, and there are facts in dispute, and there is a legal question in dispute that we ought to examine. So there are tons of mechanisms for cases that are frivolous to get thrown out in the early stages. Once you overcome those hurdles, that there is a real conflict here that we need to take a look at, then you get to the question of whether or not there was a constitutional violation. And again, that is a very high burden for the plaintiff to meet, to show that first, there was a constitutional right at all, that they were entitled to a certain type of behavior. And then second, that that right was violated. And it's in that second part, whether or not the right was violated, that the court examines whether or not the government actor acted reasonably for a person in their position. And it is really the case in our view that police are acting, are often routinely acting outside of what we would expect and what reasonable officers should be doing. And we just don't see that in other professions. I mean, there are perhaps some teachers who, in every profession, I'm sure there are some people who are really committing fraud or intentionally violating the rights of the people that they're supposed to serve, but it is just not the case that these cases are brought and that there are that many violations in these other professions. And part of that is because, I'm not sure why that is, but when we talked to the MTA attorneys, they were not super familiar with qualified immunity. It was not something that had come up very much, and we talked specifically with them about concerns in special education, because that is a sphere in which parents need to be extremely strong advocates for their children, and an area in which there are a lot of lawsuits, but because of the substantive standard where the court examines whether or not the actor acted reasonably within their training, within the profession, within the standards, those cases get dismissed at that phase. So again, qualified immunity is immunity from liability for violating constitutional rights. And in our view, anyone who is entrusted with the public trust, if that person violates a constitutional right, we are comfortable that some liability should flow from that. If the violation is so egregious that someone is entitled to damages. I mean, you're only entitled to damages if you have suffered some real and serious harm. So what we're talking about is paying of exorbitant medical bills. We're talking about funeral costs. We're talking about loss of future employment or loss of consortium. Those are the kinds of things you get damages for. And even the showing for that is very high. I mean, it is extremely hard to get all the way from the point of when something happened to you that you are recovering damages from the government. And so by the time you get to that last phase, for the court to then say you are owed $100,000 for the damage that was done to your body when you were beat up by a government actor, but it wasn't obvious that he shouldn't have beat you up, so you don't get anything. I mean, that's what we're talking about with qualified immunity. And it's just not the case that in with other government actors that you end up in that place of a serious amount of damages that now will not be awarded because of qualified immunity. And the other thing I'll add is, and I'm not an expert, but I can try to find out some more for maybe some more information for Jen to circulate, but many elected officials are entitled to absolute immunity. So you can't bring a lawsuit against a sitting legislator for an action they took in the course of legislating. I'm not sure what the case is at the municipal level or the other select planning, school zoning, historical, but I wonder if I can find a resource that talks about what kinds of immunity those folks are entitled to.
That would be great. Thank you. So for those of us who are planning meetings with our legislators or our chiefs, just to sit down and have a conversation, and they immediately say, well, qualified immunity, we're against it. Like, where should we start? What's the best place to start a conversation to have a reasonable conversation with them?
That is a great question. And the ACLU is an antagonist of the police, so I'm not sure I'm the person to ask about how to have a level-headed conversation with your local police department, to be totally honest. I will say I was on a panel the other day with Branville Barr, the commissioner of the police department in Cambridge. And he said something that struck me, that when he was trained and when other officers are trained, they are told that qualified immunity protects you from frivolous lawsuits, which is not true. A number of other things protect you from frivolous lawsuits, and qualified immunity protects you from liability only once a constitutional violation is found. So I'll say I don't really know what to do with that information, because it feels, I don't think police departments want to engage in public education from the ACLU about qualified immunity, but I think it may be worth teasing out from the person you're meeting with what their understanding of qualified immunity is. And it is not, I mean, it's something that, you know, two types of lawyers know about, the lawyers that defend police departments and the lawyers that bring constitutional rights litigation. And outside of that, you know, and law professors who teach fed courts and civil procedure, like nobody really talks about this until now. So I think it would be worth perhaps learning more about what they think qualified immunity is. I think that I know that there are some on the other side of us who know and are, you know, certainly the lawyers on the other side who defend these lawsuits do actually know what qualified immunity is, and they are playing it fast and loose with the facts and the law when they talk about it. But I also do think that there are a lot of officers who perhaps are not that familiar with, I mean, why would they be familiar with the doctrine unless they have been sued a lot? So it may be worth trying to find out more about what they think it is, and if there's a way for you to put resources in front of them. I mean, I'll, you know, you'll have to examine whether or not they seem open or movable or interested in that level of a conversation. But there's there are a lot of great resources from the Cato Institute talking about qualified immunity, and with stats and facts, and they have a great FAQ section that goes into a lot of detail that you may share. I'm stumbling because I'm having a hard time imagining that they will say, oh, like, let me read the Cato Institute and then change their mind, but you never know.
Well, I think that's a great point, Oami, because we're trying to have a reasonable conversation. So when, for example, I've told many of you on this call this, when I was discussing it with my own state senator, he was like, well, my police constituents are telling me that they're going to lose their house. So how are you going to say no to that? You know, so that's kind of, you know, what we're up against in dealing with the conversation about misinformation is like, if someone's calling you and saying, if this passes, I'm going to lose my home. Well, hopefully not, because you wouldn't have harmed or killed anyone, you know, that kind of a thing. So we're just trying to, I think that's a good resource, the Cato Institute. So I can look that up as well.
Yeah, I can drop the link in the chat, but I'll also,
and then maybe we'll just check and make sure, see if there are any remaining questions in the chat.
Yeah, I'll add, I think, Jen, your point about losing their houses, this is the top line talking point that we saw a lot when this was moving in the House. And as you just said, I mean, implicit in that is that you have done a house worth of damage to someone. And if a court has found that and doesn't assign liability to you or your employer, it means that the person who received a house worth of damage has to pay those costs themselves. That it is not that there's sort of a feeling out there that this would assign liability for the first time. That's not true. Liability exists, but it is now 100% borne by the person who has been victimized. And that is just not how it's supposed to work in the United States of America. It's just not. If you are harmed, especially if you are harmed by the government. I mean, if the US of A stands for anything, it's that no one is above the law, especially not the government. The Bill of Rights is there to hold the government accountable to individual people. It gives individual people rights against the government. And so qualified immunity is extremely un-American. And if someone has suffered that kind of damage, they should not have to carry that for the rest of their life or their family if the person has been killed.
Wow, that was great, Omi. Thank you. That was very helpful. So we'll just check the chat and see if there are any remaining questions.
If the officer is fired, does it let the city off from providing indemnification? That's a good question. It's outside my expertise, to the extent that I'm offering expertise. I don't think so, because your employer would be on the hook for damage that you cause while you're employed. So long as someone would not be able to bring a case unless the officer was an officer at the time. I mean, if the officer had already been fired and was a random, now disgruntled civilian, they're not entitled to qualified immunity anymore. So I would think that even if the person is fired, that the employer would still potentially be on the hook to indemnify the officer for actions. But the question of indemnity would be between the officer and the municipality. So liability would be assigned, and the person who was harmed would be trying to recover, and they may then sue the city if the city is not paying and is the one supposed to be paying. But sort of as with any insurance or indemnification claim, first you have the part where it's the person who was harmed against the person who did the harming, and then second is the part between the person who did the harming and the person that they want to pay for it.
Okay, and we'll take one final question. Any other questions, we're glad to follow up separately with you, but I see one from Vedna. I understand the need of qualified immunity at the federal level. As stated last week in our previous meeting, there's only been a few cases here in Massachusetts that are somewhat dated. Are we to believe that those were the only cases brought to litigation and that this exists here in Massachusetts more often than reported? If so, is there data to support that?
Yeah, so there are, again, it's the part of the problem is that because of qualified immunity, the cases don't get brought or they get thrown out at an early level. So there is a bit of a catch-22, and if it's not a problem, then there will be no litigation brought under these changes. So it's at worst zero sum. We abolish qualified immunity in Massachusetts and find out we have the best police in the country, and there are no cases here. I think you hear my voice. I'm skeptical of that. I mean, just a few weeks ago, the Department of Justice opened an investigation into some god-awful conduct in Springfield by the narcotics team. And it has got to be extremely bad for Attorney General Bill Barr under President Trump to think that the police in Springfield have gone too far. And the DOJ under the Trump administration has opened exactly one civil rights investigation into a police department in the entire country in the last 4 years, and that was in Springfield last month. So it is happening. There is police brutality. There are cases that should be litigated, but for whatever reason, those cases are not brought, or they don't make it all the way to the end, and not for whatever reason, likely for qualified immunity. The other problem with the Massachusetts Civil Rights Act that I did not delve into is that it has these words, threats, intimidation, or coercion, and the state Supreme Court has interpreted those words very literally to mean that unless the constitutional violation was accompanied by threats, intimidation, or coercion, you can't bring a lawsuit under the MCRA. So that means if a Springfield police officer punches you in the face, but doesn't say, I'm going to punch you in the face, or doesn't say anything at all, you can't bring a case under the MCRA. So that's the other problem that the Senate bill would fix, and that the House bill would not fix. So we believe, and our legal department as people who would bring a lot of these cases believe that if those two problems are fixed, the threats, intimidation, coercion, and qualified immunity, that people will be able to vindicate their rights in court. And because the MCRA presents these two hurdles, so the federal civil rights law does not present this hurdle, the threats, intimidation, or coercion piece, it just means that litigators bring all the Massachusetts cases under the federal law and not the state law, which is terrible because the whole point of the state law is that it's supposed to create an avenue that has been foreclosed by the federal law, but the state law gets you nowhere. So the cases are mostly brought under the federal law, and there are many, many, many examples of cases brought under the federal law, dismissed with qualified immunity in Massachusetts more recently. And one very sort of recently, within the last, I think, 5 years, brought by the ACLU, a woman who was having, who had bipolar disorder and was in mental health crisis and had run away from the facility that she was being treated at. The facility called the police to help find her. An officer found her, threw her to the ground. He was on top of her and she wouldn't put her hands behind her back, but he was on top of her and he weighed like 75 pounds more than her. She wouldn't put her hands behind her back, so he tased her on her bare skin. And we brought a case in federal court and it was thrown out on qualified immunity because the court said it was not clearly established that the officer who weighed 75 pounds more than a woman that he knew was in mental health distress didn't put her hands behind her back when he told her to. So it's not great in Massachusetts, and I hope the legislature will do something about it.
Oami, thank you so much for all your help. Hopefully we answered a lot of questions. I know it's kind of a deep topic and I didn't know any of it. I don't know about anyone else until, unfortunately, the murder of George Floyd. So now we're learning so much, unfortunately, but hopefully we can pass meaningful police reform in Massachusetts. So thank you again for all your help. I'll be following up with resources and the recording to everyone who attended, and feel free to email us with any questions. Thank you, everyone. Good night.
Thanks, everyone. Good luck.